we're seeing a lot of state officials react to this ruling, including Attorney General Dana Nessel. I spoke with her this afternoon about why she says this is a victory, but there's more work to be done here in Michigan.
We're very pleased with it. And, for those of us like myself who believe that no one should be fired from their job, nobody should be discriminated against in job opportunities because they identify as LGBTQ, I think it's a great victory, but it's a very narrow victory. So I think people have to be cautious in terms of how they apply that to the state of Michigan. So that doesn't directly apply to Michigan state law. Under our civil rights statute, which is the Elliott-Larsen Civil Rights Act, we don't have sexual orientation or gender identity as specifically protected classes under our state law. And we don't have any rulings yet in Michigan that the word sex, which also appears in our state civil rights law, encapsulates sexual orientation or gender identity. Hopefully what this means is when there are cases that go through the state courts, they will apply it in the same way that the United States Supreme Court did. But we don't know that yet, and that remains to be seen. Personally, whether this happens through a change legislatively, whether it happens through the state courts, or whether it happens through a ballot initiative, I would like to see the Elliott-Larsen Civil Rights Act amended to specifically include gender identity and to specifically include sexual orientation, so there's no ambiguity in the law whatsoever.
And because that amendment is not there yet at the state level, how does that potentially impact your office and cases that may arise?
Well, generally speaking, when you have someone who claims discrimination, they believe that they were denied employment or they were fired because of their sexual orientation or gender identity, that's a complaint that goes to the Department of Civil Rights for them to investigate. And if they find that a person was terminated from their job or denied employment for those reasons, then that is something that an employer can be held accountable for. We very much hope that those cases now will go up through the Michigan courts and that there'll be a finding by the Michigan Supreme Court that terminating somebody for being LGBTQ is in fact illegal discrimination.
Now, this decision may also impact a future ballot here in Michigan. Fair and Equal Michigan, a group working to get LGBTQ rights added to the Elliott-Larsen Act, says their legal counsel is now analyzing the SCOTUS ruling and working to determine if they need to continue their petition drive. We told you last week about the extension the group received to gather signatures, but likely it won't happen in time for this November election.